You're nothing but a troublemaker from the projects. Look at me when I'm sentencing you." Judge Victor Langford's voice thundered across the courtroom as the gavel crashed down. Young Nia Caldwell stood frozen before him, the all-white audience snickering behind her. Judge Langford descended from the bench, invading her personal space. He snatched her court documents and let them scatter across the floor. "Pick them up now." His shoe tapped impatiently as she knelt to gather the papers. Her public defender remained silent, eyes averted. "Remember your place?" Langford sneered, strutting back to his position of power. Nia's jaw tightened. She gripped her small notebook like a shield against her chest. That notebook, trembling in her hands, contained evidence that would obliterate Langford's career within hours. Dawn broke over the county courthouse. Nia adjusted her modest blue blouse, the nicest one she owned. Her father, Darius, walked beside her, his maintenance uniform freshly pressed. They couldn't afford to miss work, but they couldn't afford a private attorney either. "Remember what I told you?" Darius whispered. "Stand straight. Speak clearly. Look them in the eye." Nia nodded, clutching her notebook. Inside, pages of careful observations filled the margins. She had been preparing for this moment. Their assigned public defender, Mr. Fletcher, met them in the hallway. He shuffled through his overflowing case files until he finally located Nia's paperwork. "Caldwell, Nia Caldwell. Right, the hotel trespassing." Fletcher barely made eye contact. "Judge Langford's courtroom today. Look, you should take the plea deal. First offense. Well, technically second if we count that park incident." "But I wasn't—" Nia began. Fletcher cut her off. "Langford is tough on folks like you. Take the deal. Community service beats juvenile detention." Across town, Judge Victor Langford adjusted his silk tie in the mirror of his Westlake mansion. His wife placed his coffee precisely where he expected it. "Juvenile cases today," he complained, checking his watch. "Delinquents wasting the court's time. There's one about trespassing at the Grand Hotel." He pulled out his phone and speed dialed. "Preston, it's Victor Langford about that trespasser at your hotel. Don't worry, I'll make an example of them. Can't have people thinking they can walk into establishments where they don't belong." Back at the courthouse, Nia sat quietly observing the proceedings before her case. A white teenager caught shoplifting received a stern warning and community service. Another white defendant with vandalism charges got a reduced fine after his father spoke to the judge. Then a black teenager appeared, charged with loitering. Langford's demeanor transformed instantly. His voice became cold and condescending. The sentence: maximum community service and a substantial fine. Nia's hand moved quickly across her notebook page. Her observations grew more detailed with each case. As the bailiff called, "Caldwell, Nia." A sharp-eyed woman in the back row sat forward, her attention locked on Judge Langford. Nia approached the defendant's table, steps measured and deliberate. Judge Langford barely looked up from his papers, a dismissive frown forming at the corners of his mouth. "Another trespassing case," he sighed dramatically. "Seems to be an epidemic of young people thinking they can go wherever they please." Mr. Fletcher cleared his throat. "Your Honor, my client is a first-time offender in this context. We're prepared to discuss a reasonable penalty." "Second-time offender," Langford interrupted, tapping a folder. "I see a prior incident at Westside Park after hours." "I was studying," Nia said quietly. "The lights at home went out again. The park has benches under streetlights." Langford's eyebrows rose. "Did I ask you to speak? Mr. Fletcher, control your client." The prosecutor stood, straightening his tie. "Your Honor, the defendant was discovered in a restricted area of the Grand Hotel, specifically near the executive conference rooms where valuable equipment is stored. Security footage confirms she had no legitimate business there." What do you have to say for yourself? Langford addressed Nia directly now, leaning forward. I was there for a program, she began. A program? Langford scoffed. The Grand Hotel doesn't run programs for... He stopped himself, but his implication hung heavy in the air. Your Honor, Fletcher interjected weakly, perhaps a fine and standard community service would... Mr. Fletcher, this court takes trespassing in upscale establishments seriously. It begins with trespassing, ends with theft. Langford's gaze slid over Nia's neat but modest clothing. The defendant has already shown a pattern of being where she doesn't belong. Nia's father shifted in his seat, knuckles white against his knees. A court officer stepped slightly closer to him in warning. Throughout the exchange, Nia wrote steadily in her notebook, her pen moving across the page. Langford noticed. What are you writing? He demanded suddenly. Nia looked up, startled. Just notes, Your Honor. Hand it over. Langford extended his palm. This is my courtroom, not your classroom. Nia hesitated, then slowly passed her notebook forward. The bailiff took it to Langford, who flipped through the pages with growing irritation. His mocking smile faltered when he saw the detailed documentation of his courtroom patterns, complete with quotes and statistical notations. Langford's face tightened momentarily before his practiced judicial mask returned. He snapped the notebook shut and tossed it back toward Nia with exaggerated disdain. Quite the little researcher, aren't we? He sneered. Taking notes won't change the facts of your case. He leaned back, fingers steepled beneath his chin. I've decided that a standard community service arrangement is insufficient here. Ms. Caldwell clearly has an attitude problem that needs addressing. Fletcher started to object, but Langford silenced him with a raised hand. Stand up, Miss Caldwell, Langford commanded. Come to the center of the courtroom. Nia rose slowly, uncertainty in every movement. The courtroom watched as she stepped forward, standing alone on the cold marble floor. Now, Langford continued, satisfaction creeping into his voice, I want you to explain to everyone present why you thought you belonged in a 5-star hotel like the Grand. What possible legitimate reason could you have? I was invited to... Nia began. Speak up, Langford barked. The court reporter can't hear your mumbling. Nia swallowed hard. I was invited to participate in a program. A program? Langford repeated, drawing out each syllable for the audience's benefit. And who exactly invited you to this mysterious program? The National Merit Scholarship? Langford laughed, cutting her off. The National Merit Scholarship Program doesn't meet in hotel conference rooms. They meet in schools, universities. He addressed the courtroom directly. Creative, I'll give her that. Whispers rippled through the spectators. Nia stood perfectly still, her face a careful mask hiding the humiliation burning beneath. Turn around, Miss Caldwell, Langford instructed. Let everyone see your idea of appropriate courtroom attire. Nia hesitated. That wasn't a suggestion, Langford snapped. She turned slowly in a circle, her simple blue blouse and dark skirt modest and clean, if not expensive. Your Honor? Fletcher finally spoke up. This is highly irregular and potentially... Mr. Fletcher, are you questioning my methods? Langford's voice dropped dangerously. Because I can hold you in contempt as easily as your client. Fletcher subsided immediately. Langford lifted his phone. I have Preston Whitaker, owner of the Grand Hotel, on the line. Mr. Whitaker, was there any educational program scheduled in your conference rooms on that afternoon? A tiny voice responded through the speaker. Absolutely not, Your Honor. Our conference center is exclusively for business clients and hotel events. Security reported the young woman near our Platinum Suite, where we keep valuable equipment. Throughout the exchange, The woman in the back row continued observing, her tablet now recording every word. Two well-dressed individuals slipped in beside her, conferring in hushed tones. Nia stood alone in the center of the courtroom, back straight despite the public humiliation. A single tear threatened at the corner of her eye, but she blinked it back fiercely. "Thank you, Mr. Whitaker." Langford concluded the call. "The court appreciates your time." He turned his attention back to Nia. "Still maintain you were there for a program?" "Yes, Your Honor," she answered, her voice steadier than before. Defiant to the end, Langford sighed theatrically. Nia's phone buzzed in her pocket. She didn't reach for it. The screen flashed briefly with a message. "Hold steady. Justice incoming. You're not alone." "Court will recess for 15 minutes, Langford announced abruptly. "Miss Caldwell, don't leave the building. We're not finished with your case." The bailiff called for all to rise as Langford exited. The moment he was gone, whispers erupted throughout the courtroom. Nia returned to her seat, face carefully composed despite the humiliation still burning in her chest. "I need to use the restroom," she whispered to her father. Darius nodded, concern etched in every line of his face. "You're handling this with more strength than I could," he said softly. "I'm proud of you." Nia slipped away, finding refuge in the courthouse bathroom. Only there, in a locked stall, did she allow herself a moment of vulnerability. Silent tears streamed down her face as she gripped the edge of the sink, knuckles white with tension. She splashed cold water on her face, erasing the evidence of her tears. The bathroom door swung open. Nia straightened, composing herself. A black woman in her 40s entered, dressed in an impeccable charcoal suit. She was the same woman who had been watching from the back row. "Nia Caldwell?" she asked, voice low and confident. Nia tensed. "Yes." "Dr. Simone Hargrove, Educational Director for the National Merit Scholarship Program." She extended a business card with the organization's embossed logo. "I believe we had an appointment at the Grand Hotel that was interrupted." Recognition flashed across Nia's face. "Dr. Hargrove, but the hotel owner said, Preston Whitaker doesn't personally manage conference bookings," Hargrove explained. "Our event was arranged through their corporate office, not the local management. We booked the same space quarterly through their diversity initiative program." She leaned against the counter. "I must apologize for not intervening sooner. When you didn't arrive for your interview, we investigated. What I've witnessed today is disturbing, but not, unfortunately, surprising." Hargrove gestured toward Nia's notebook. "Your documentation of Langford's behavior caught our attention. We've received similar reports from other minority students." Meanwhile, in his chambers, Langford loosened his tie and answered his private line. "Victor, it's Senator Grayson. Wanted to give you a heads up. Judicial review appointments are coming up. There's been some chatter about diversity on the bench." Langford laughed. "Political correctness gone mad. Don't worry about me. Many years on this bench and no one has successfully challenged my rulings yet." "Still might want to tread carefully," Grayson warned. "Actually handling one of those cases now," Langford replied. "Another delinquent who needs to learn respect for private property. Making an example of her as we speak." Back in the bathroom, Dr. Hargrove made several calls in rapid succession. First to the hotel's corporate headquarters, confirming the scholarship program booking. Next to the State Judicial Review Board, speaking in clipped, urgent tones. "Yes, it's happening exactly as reported. We're witnessing it firsthand." She listened briefly. "Understood. Everything's being documented." Her final call was to a senior partner at Marshall and Reed Law Offices. "Grant, Simone Hargrove, we need that pro bono representation we discussed. Right now, actually." She turned to Nia. We've been building a case against Langford. Your detailed notes provided exactly the pattern evidence we needed, but we required clear documentation of his behavior in court. The bathroom door opened again. Darius entered cautiously. Nia, are you okay? Dr. Hargrove introduced herself, quickly outlining the situation. Mr. Caldwell, your daughter was legitimately at that hotel for a scholarship interview. Judge Langford's treatment of her today is part of a documented pattern of discriminatory behavior from the bench. Darius's expression shifted from confusion to determination. What do we do? Return to the courtroom. Nia needs to remain composed. No matter what Langford says or does, the truth will come out, but timing is crucial. Nia took a deep breath. I can do this. As they prepared to return, Nia noticed the badge clipped to the lanyard of Hargrove's colleague who had just joined them. The insignia read, Governor's Ethics Commission, Special Investigation Unit. The woman caught Nia's eye and tapped her tablet deliberately, confirming that every word, every action in that courtroom was being recorded. Court resumed with a sharp bang of Langford's gavel. His mood appeared to have darkened during the recess, his mouth set in a tight line as Nia returned to her place at the defendant's table. After consideration, Langford announced without preamble, I've determined an appropriate penalty for Ms. Caldwell's offense and continued dishonesty. He shuffled papers for dramatic effect. The defendant will write a public apology to be published in the county newspaper, acknowledging her trespassing and dishonesty before this court. Additionally, she will complete 200 hours of community service. A ripple of surprise passed through the courtroom at the unusually harsh sentence. Furthermore, Langford continued, satisfaction evident in his tone, that community service will be performed at the Grand Hotel itself. Perhaps cleaning bathrooms will teach a more lasting lesson about respecting private property than empty words could. Fletcher shifted uncomfortably. Your Honor, that seems excessive for a first time. Second offense, Langford corrected sharply. And given the defendant's attitude, I believe it's entirely appropriate. Do you wish to object formally, Mr. Fletcher? Perhaps risk a contempt citation yourself? Fletcher deflated visibly. No, Your Honor. Very well, then. Objection. The word cut through the courtroom. All heads turned as a tall man in an expensive suit rose from the back row and strode forward. Grant Ellison, Your Honor, Marshall and Reed Law Offices. I'll be taking over Ms. Caldwell's defense effective immediately. Langford's face flushed. This is highly irregular, Mr. Ellison. We're in the middle of sentencing. Which is precisely why I'm intervening now, Ellison replied smoothly, placing his credentials before the court. My motion to substitute as counsel has already been filed with the clerk. Since no formal sentence has been entered into the record, we're well within procedural bounds. Langford examined the paperwork, searching for any technicality to refuse it. Finding none, he nodded curtly. Fine, Mr. Fletcher. You're excused. Fletcher gathered his papers, relief evident as he retreated. Ellison wasted no time. Your Honor, the defense moves that all charges against Ms. Caldwell be dismissed immediately due to lack of evidence and improper procedure. Denied, Langford snapped. Then I must inquire, Ellison continued calmly, why Miss Caldwell's case is receiving such unusual treatment compared to similar cases heard earlier today. Langford's knuckles whitened around his gavel. Each case is unique, Counselor. Indeed, Ellison agreed, producing a folder. Which is why I've taken the liberty of reviewing your court records for recent months. There appears to be a statistical anomaly in sentencing patterns based on defendant characteristics. Are you accusing this court of impropriety? Langford's voice rose dangerously. I'm simply entering facts into the record, Your Honor, Ellison replied. More observers entered the courtroom quietly, some taking notes, others watching Langford intently. "I'll hold you in contempt," Langford threatened. "Your Honor," Ellison said with unruffled calm, "I request that the court record reflect your hostility toward the defense's legitimate inquiry. Would you like to explain why the defendant's legitimate reason for being at the hotel wasn't verified before this proceeding began?" Langford straightened in his chair, jaw working beneath flushed skin. The courtroom fell silent, spectators leaning forward in anticipation. "The owner of the Grand Hotel verified no such program existed," Langford stated flatly. "His word is sufficient for this court." "Is it?" Ellison removed a document from his briefcase. "I submit as evidence confirmation from the Grand Hotel's corporate events office, documenting that the National Merit Scholarship Program reserved the Oakwood Conference Room from 2 to 5 that afternoon." He approached the bench, offering the document. Langford took it reluctantly, eyes scanning the official letterhead. "Furthermore," Ellison continued, "Ms. Caldwell was there by specific invitation, as evidenced by this email from Dr. Simone Hargrove, educational director of the program." The prosecutor rose hesitantly. "Your Honor, the state wasn't provided with this evidence." "Because no one bothered to investigate," Ellison responded. "The defense shouldn't have to prove innocence when the prosecution hasn't established guilt." Langford's phone rang. He answered it on speaker, maintaining the pretense of judicial authority. "Mr. Whitaker, were you aware of any National Merit Scholarship event at your hotel that day?" Whitaker's voice sounded less certain now. "I don't personally handle all bookings, Your Honor. The corporate office sometimes arranges events without my direct involvement." "So you testified earlier without complete knowledge," Ellison interjected. "Objection," the prosecutor called out. "Sustained," Langford said quickly. "Mr. Ellison, you will not interrogate witnesses without permission." More officials entered the courtroom. A woman with a State Bar Association badge took a seat in the front row, notebook open. Langford noticed the growing audience, sweat beading at his temples despite the courtroom's air conditioning. He tugged at his collar, attempting to regain control of the proceedings that were rapidly slipping away. "The court will take these new documents under advisement," Langford announced. "However, this last-minute evidence appears designed to ambush the court and the prosecution." "With respect, Your Honor," Ellison countered, "proper investigation would have revealed these facts before Miss Caldwell was publicly humiliated. One phone call to verify her story would have sufficed." Langford turned his frustration toward Nia. The defendant should have spoken up more clearly about her alleged appointment. "Your Honor," Ellison said, voice hardening for the first time. "Ms. Caldwell attempted to explain multiple times. Court transcripts will show you interrupted her repeatedly and dismissed her explanations without consideration." The mood in the courtroom shifted palpably. Spectators exchanged glances, some nodding in recognition of the truth being spoken. The prosecutor busied himself with papers, clearly distancing himself from Langford's approach. Langford checked his watch with theatrical impatience. "This court's time is valuable, Mr. Ellison. We can't afford to waste it on prolonged discussion of a simple trespassing case." Ellison maintained perfect composure, hands clasped before him. The contrast between his professional demeanor and Langford's increasing agitation became more pronounced with each exchange. "Speaking of time, Your Honor," Ellison said evenly, "perhaps you could explain why cases involving minority defendants consistently receive more of your valuable court time than those involving white defendants." "How dare you!" Langford exploded, slamming his gavel with such force that the sound echoed like a gunshot through the courtroom. "This is contempt of court. One more insinuation like that and I'll have you removed." Ellison didn't flinch. "I'm simply asking about a statistical anomaly in your court records, Your Honor. Public records show minority defendants receive an average of 43 minutes of court time. while white defendants averaged 17 minutes for comparable charges. "Clear the courtroom," Langford shouted, face mottled with rage. "Everyone but essential personnel out." No one moved. The bailiff shifted uncomfortably, looking between Langford and the growing number of official observers. Ellison remained unruffled. "I'd like to call Dr. Simone Hargrove to provide context regarding Ms. Caldwell's presence at the Grand Hotel." Before Langford could object, Dr. Hargrove approached the witness stand. After being sworn in, she sat with perfect posture, credentials displayed prominently on the lanyard around her neck. "Dr. Hargrove," Ellison began, "please explain the National Merit Scholarship Program and specifically why Nia Caldwell was at the Grand Hotel." "The National Merit Scholarship Program identifies exceptional students from underrepresented communities," Hargrove explained. "Nia Caldwell came to our attention through her extraordinary academic achievements despite limited resources. She maintains a 4.0 GPA while working part-time and volunteering at her community library." Langford interrupted. "This character testimony is irrelevant to the trespassing charge." "It speaks directly to motive, Your Honor," Ellison countered. "Ms. Caldwell had legitimate business at that location, which negates the essential element of the trespassing charge." Hargrove continued, "We conduct interviews at the Grand Hotel specifically because it provides a professional, neutral environment for evaluations. Candidates come from multiple districts." Langford leaned forward. "Why not meet at a school or public library? Why a luxury hotel?" "We want our candidates to feel valued," Hargrove replied evenly. "Many come from neighborhoods where professional environments are limited. The hotel partnership demonstrates our commitment to treating these scholars with the same respect afforded to business executives." The prosecutor, sensing the shifting tide, stood. "Your Honor, in light of this new evidence, the state requests time to investigate these claims before proceeding." Langford ignored him, fixating instead on Nia, who sat with quiet dignity, her notebook open on the table before her. She continued to write, documenting every word of the proceedings. "Miss Caldwell," Langford snapped, "I've had enough of your note-taking. Hand over that notebook immediately." Ellison stood. "Objection, Your Honor. Those notes constitute private attorney-client communications and work product." Langford's patience shattered. "I want to see what she's writing about my courtroom." The admission hung in the air, revealing Langford's true concern, not justice, but his reputation. Nia looked up, meeting Langford's gaze directly for the first time. The room fell silent, tension stretching between them like a wire about to snap. "Actually," Nia said, her voice clear and steady, "I'm happy to explain exactly what I've been documenting if you're prepared for everyone to hear it." The silence in the courtroom deepened. Langford's momentary satisfaction at Nia's apparent surrender quickly faded as he registered the confidence in her voice. "Proceed," he said, caution creeping into his tone. Nia rose, standing straight before the court. Gone was the intimidated teenager from earlier. In her place stood a young woman with purpose radiating from every inch of her slender frame. "For months, I've been tracking judicial misconduct across multiple courtrooms for a student research project on equal justice in our county's legal system." She opened her notebook, revealing meticulous charts, graphs, and dated entries. "What began as a school assignment evolved when I noticed disturbing patterns. Defendants of color consistently receive harsher sentences than white defendants for identical charges. Dismissal rates for white defendants are 78% higher. Court-appointed attorneys for minority defendants are given an average of 4.3 minutes to consult before proceedings, while attorneys for white defendants average 12.7 minutes. Langford attempted to interrupt, but Ellison raised his hand. "Your Honor, You specifically requested that Ms. Caldwell explain her documentation. Please allow her to finish. Nia continued, her voice growing stronger. I tracked 137 cases across 3 county courtrooms, including 42 in this courtroom specifically. The data shows systemic disparities that cannot be explained by case differences alone. She turned a page in her notebook. Judge Langford, in your courtroom specifically, black defendants receive sentences averaging 67% longer than white defendants for identical charges. You interrupt black defendants an average of 7.2 times per hearing, compared to 1.3 times for white defendants. Murmurs spread through the courtroom. Langford pounded his gavel ineffectively. This is preposterous, the ramblings of a child with no understanding of the justice system. Dr. Hargrove stood. Nia Caldwell is not just any student, Your Honor. She's the youngest ever recipient of the State Youth Leadership Award presented by Governor Chandler. Her research project on justice system disparities has been selected for national presentation at the Constitutional Rights Foundation's Youth Summit. Hargrove approached the bench, producing a folder. Her meeting at the Grand Hotel served 2 purposes: the scholarship interview and meeting with the hotel's corporate counsel about their community initiatives, which she's evaluating as potential models for judicial reform. The mysterious woman from the back row stepped forward, badge prominently displayed. Director Kendra Wallace, State Judicial Ethics Committee. Judge Langford, we've been monitoring your courtroom after receiving multiple formal complaints about disparate treatment. Wallace gestured to her colleagues. Our committee has reviewed Ms. Caldwell's preliminary findings and found them consistent with our own investigations. Her statistical methodology is remarkably sophisticated for someone her age. Langford's face paled. This is an ambush, a setup. No, Your Honor, Wallace replied calmly. This is accountability. Ms. Caldwell acted independently, but her documentation provides additional evidence for our ongoing investigation. Langford attempted to regain control. None of this changes the fact that the defendant was trespassing at the Grand Hotel. Ellison approached with a tablet. Security footage from the Grand Hotel, Your Honor. It clearly shows Ms. Caldwell being escorted to the Oakwood conference room by hotel staff exactly as she claimed. He played the video. Nia appeared presenting identification at the front desk. A staff member in a hotel uniform guided her toward the elevators. The timestamp matched exactly with the alleged trespassing incident. The trespassing allegation itself was false, Ellison stated firmly. Ms. Caldwell had permission to be on the premises, was there for legitimate business purposes, and was in an authorized area. Director Wallace addressed the court directly. The Ethics Committee has been compiling evidence on Judge Langford. We needed clear documentation of his behavior in court with multiple witnesses. Today's proceedings provided exactly that. Langford looked around the courtroom, finally recognizing the trap that had closed around him. State officials lined the back wall. Court reporters documented every word. Several respected attorneys from major firms sat in observation. This is a witch hunt, he sputtered. I've served on this bench for many years. Yes, Wallace agreed. And during those many years, you've demonstrated a pattern of discriminatory behavior that undermines the fundamental principle of equal justice under law. She opened an official folder, extracting a document bearing the state seal. Judge Victor Langford, by authority of the State Judicial Ethics Committee and the Supreme Court of this state, you are hereby suspended from the bench, effective immediately, pending a full investigation into judicial misconduct, abuse of power, and systematic discrimination in your courtroom. The gavel fell from Langford's hand, hitting the bench with a dull thud that echoed through the suddenly silent courtroom. Within hours, the county courthouse transformed into a hive of urgent activity. In the main courtroom, Chief Judge Lena Sinclair presided over an emergency hearing regarding Nia's case. Her demeanor contrasted sharply with Langford's, attentive, measured, and genuinely concerned. After reviewing the evidence, Judge Sinclair announced, "This court dismisses all charges against Nia Caldwell with prejudice. The record will show these charges were without merit and improperly pursued." She looked directly at Nia. "Miss Caldwell, on behalf of this court and our justice system, I extend a formal apology for your treatment today. What you experienced represents a failure of the principles we are sworn to uphold." Preston Whitaker, owner of the Grand Hotel, sat uncomfortably in the gallery. After the hearing, he approached Nia and her father. "Miss Caldwell, I want to personally apologize," he said, extending his hand. "I spoke without full knowledge of the situation and contributed to this injustice. After learning about your research, I'd like to offer you an internship in our corporate social responsibility department. Your perspective would be invaluable." Across town at the Judicial Ethics Committee headquarters, Director Wallace and her team began the monumental task of reviewing Langford's case history. Analysts pulled digital records while others compiled physical documentation dating back years. "The pattern is even clearer than we suspected," Wallace told her deputy, scrolling through a data visualization on her screen. "Minority defendants received sentences averaging 60% longer than white defendants for identical charges. First-time white offenders received probation at 7 times the rate of minority offenders." A junior analyst entered with another report. "Director, we've identified 23 cases with particularly egregious sentencing disparities. 3 defendants are still incarcerated despite circumstances nearly identical to white defendants who received probation." Wallace nodded grimly. "Flag those for immediate review. Contact the public defender's office. We need to file motions for reconsideration." The media descended with predictable hunger. Initial headlines focused on the sensational. "Teen turns tables on biased judge." "Student researcher exposes courthouse corruption." Television crews camped outside the courthouse, competing for interviews with anyone connected to the case. By evening, more thoughtful coverage emerged. The State Tribune published an in-depth analysis titled "Systemic Bias When Those Who Judge Are Not Judged." Legal experts appeared on news panels discussing the broader implications. "What happened today represents both a failure and a success," Professor Lena Montgomery, a judicial ethics expert, explained during a primetime interview. "The failure is that a judge was allowed to demonstrate bias for years without consequence. The success is that finally, through the diligence of a remarkable young woman and proper oversight, accountability arrived." Nia found herself thrust into an unexpected spokesperson role. At a hastily arranged press conference, she stood beside Dr. Hargrove, composed despite the forest of microphones before her. "My research wasn't about targeting any individual," she explained carefully. "It was about documenting patterns that affect real people's lives every day. One biased judge can impact thousands of families over a career." Her research, combined with the Ethics Committee's findings, provided compelling evidence for legislative action. State Senator Lyle Parkman announced plans to introduce the Judicial Accountability Act. Nia received an invitation to speak at the press conference announcing the bill. "Ms. Caldwell's meticulous documentation provided the evidence we've needed," Parkman told reporters. "This legislation will establish independent review of sentencing patterns, mandatory bias training, and a more transparent process for judicial appointments." At the Grand Hotel's corporate headquarters, executives launched an internal investigation into how the miscommunication occurred. They discovered that Whitaker's executive assistant, Gregory Palmer, deliberately failed to inform him about educational programs using their facilities. "I didn't think those kinds of events belonged at our establishment," Palmer admitted during his termination interview. "They don't generate revenue and attract the wrong element." His dismissal was immediate, accompanied by a company-wide directive on the hotel's inclusion initiatives and non-discrimination policies. Langford retreated to his Westlake mansion, doors locked against the media camped outside. He hired Julian Kraft, a high-profile defense attorney known for representing disgraced public officials. Judge Langford's comments have been taken out of context, Kraft told reporters from Langford's driveway. His distinguished career speaks for itself. We are confident that a full and fair review will exonerate him from these politically motivated accusations. The statement backfired when the Ethics Committee released transcripts of Langford's courtroom remarks from multiple cases, revealing a consistent pattern of condescension and bias toward minority defendants. Even his political allies began distancing themselves, their statements evolving from strong support to waiting for all the facts. Governor Chandler addressed the situation during a scheduled press conference. The integrity of our justice system depends on fairness and impartiality from every judge in every courtroom. My administration takes these allegations extremely seriously. We will follow the Ethics Committee's investigation closely and take appropriate action based on their findings. Behind closed doors, the governor's legal counsel reviewed options for removing Langford permanently if the investigation confirmed the allegations. They also began considering potential replacements with an emphasis on candidates with demonstrated commitments to equal justice. The State Bar Association announced its own investigation into potential ethics violations by Langford. Judicial misconduct of this nature, if confirmed, represents a serious breach of professional ethics, their statement read. The Bar Association is committed to maintaining the highest standards of legal practice, including on the bench. Former defendants from Langford's court began coming forward with their stories. Community legal aid organizations established a hotline for those who believed they had received biased treatment. Within days, they recorded over 200 calls. Ellison's law firm, Marshall & Reed, announced they would provide pro bono representation for appeals in the most egregious cases. Equal justice isn't just an ideal, Ellison told the press. It's a constitutional guarantee that must be enforced. Nia returned to school, attempting to resume normal life despite her newfound recognition. Classmates and teachers regarded her with a mixture of admiration and curiosity. Her history teacher asked her to speak to the class about civic engagement and the justice system. Sometimes change starts with simply paying attention, she told her peers. Documenting what you see, speaking up when something isn't right. As the investigations continued, a forensic audit of Langford's communications revealed something even more damning. Emails between Langford and certain prosecutors showed coordination to target specific types of defendants, with explicit discussion of maintaining deterrent sentencing in problem communities. The Ethics Committee immediately forwarded these communications to the State Attorney General's office, transforming the case from professional misconduct to potential criminal conspiracy. The State Judicial Center's largest hearing room reached capacity an hour before proceedings began. Television cameras lined the back wall, their red lights blinking in silent witness. Security guards checked credentials at every entrance. Victor Langford entered through a side door, avoiding the media gauntlet outside. His expensive suit hung slightly loose on his frame, evidence of weight lost during sleepless nights. Julian Kraft walked beside him, whispering last-minute advice. Gone was Langford's imperious stride and confident smirk. He took his seat at the respondents' table with uncharacteristic meekness, eyes downcast. The irony escaped no one. The judge, now judged, sitting exactly where countless defendants once trembled before him. The 5-member Judicial Review Panel entered, led by Justice Rebecca Chen from the State Supreme Court. Their faces revealed nothing as they took their positions. This hearing will determine whether Judge Victor Langford has violated the Judicial Code of Conduct and Constitution of this state, Justice Chen announced. These proceedings are not criminal in nature, but will establish whether Judge Langford remains fit to serve on the bench. Director Wallace presented the Ethics Committee's findings first. Evidence mounted in methodical, devastating sequence. Statistical analysis of Langford's sentencing patterns, testimony from former defendants, court transcripts revealing disparate treatment, and the damning private communications. In this email, Wallace highlighted on the projection screen, Judge Langford specifically instructs Prosecutor Phillips to seek maximum penalties for defendants from what he terms problem neighborhoods, while offering diversion programs for kids who made mistakes from good areas. Langford's former clerk, Alexis Rodriguez, testified about being instructed to schedule certain types of cases strategically. Judge Langford wanted specific prosecutors assigned to cases involving minority defendants, she explained. He called it matching the right attorney to the right case, but it was clearly about ensuring harsher outcomes. As evidence accumulated, Langford's defense strategy crumbled. Former allies abandoned him one by one. Preston Whitaker, initially called as a character witness, instead provided a sworn statement about Langford's previous comments regarding keeping undesirables away from establishments like the Grand. He told me during a golf game that strict sentencing was necessary to maintain property values and keep certain elements where they belong, Whitaker's statement read. At the time, I didn't challenge these comments. That failure of moral courage is something I now deeply regret. Even more damaging, Assistant District Attorney Mark Phillips admitted to feeling pressured by Langford. There was an unspoken understanding, Phillips testified. If you didn't pursue the sentences he wanted, your cases wouldn't be scheduled favorably. Young prosecutors who needed wins to advance their careers understood this clearly. As the second day of hearings concluded, Langford requested permission to make a statement. Justice Chen granted his request, perhaps hoping for contrition. Langford approached the podium slowly. He began with practiced humility, expressing regret for any misunderstandings and citing his many years of dedicated service. But as questioning from the panel intensified, his veneer cracked. "You don't understand the realities of maintaining order," he snapped when Justice Chen pressed him about the email evidence. "Someone has to make tough decisions to keep communities safe. And those tough decisions just happen to fall disproportionately on minority defendants," Justice Chen asked. Langford's restraint finally shattered. "Look at the statistics. Look at where the crime comes from. Someone needs to keep these communities in line or we all suffer. I was doing what needed to be done while the rest of you hide behind political correctness." A collective gasp rippled through the hearing room. Camera operators zoomed in on Langford's flushed face as he continued his tirade. "You want to know the truth? Fine. Some people respond to second chances, others only understand consequences. I gave each what they needed, and I make no apologies for it." The outburst confirmed every allegation against him. Court reporters' fingers flew across keyboards, capturing every damning word. Within minutes, his statement trended across social media platforms, the unvarnished prejudice impossible to misinterpret. The panel deliberated for less than 2 hours before returning their unanimous decision. This panel finds that Judge Victor Langford has egregiously violated the Judicial Code of Conduct through demonstrated bias, abuse of power, and actions that have undermined public faith in our justice system, Justice Chen announced. "We recommend his permanent removal from the bench and referral to the State Bar Association for disbarment proceedings." She continued, her voice firm. "Additionally, we are referring our findings to the Attorney General's office for review of potential civil rights violations under state and federal law." Langford sat motionless, the reality of his complete downfall finally sinking in. Many years of power and prestige evaporated. As Langford shuffled from the hearing room in defeat, he froze in the hallway. Nia stood directly in his path. A documentary crew captured the moment his eyes met those of the young woman who had catalyzed his downfall. In the months that followed, fresh waves of reform swept across the state's judicial landscape. The Langford case, once headline news, transformed into something more significant, a catalyst for systemic change. In the Capitol, Chief Justice Monroe addressed the annual judicial conference, hundreds of judges filling the auditorium. The integrity of our system depends not just on the letter of the law, but on its equal application, she declared. The Langford case forced us to confront uncomfortable truths about implicit bias and institutional failure. The statewide audit of judicial conduct, launched in the wake of Langford's removal, identified 5 other judges with similar patterns of discriminatory sentencing. 2 resigned rather than face investigation. 3 others contested the findings, but their cases were reassigned pending review. This isn't about punishing individual judges, explained Judicial Ethics Director Wallace during a panel discussion at the State Bar Association. It's about healing a system that has lost the public's trust. Every biased ruling damages faith in justice itself. New requirements cascaded through the system. All judges must now complete implicit bias training annually. Sentencing data is published quarterly, searchable by demographics to identify disparities. A citizen review panel adds community oversight to judicial appointments, ensuring diverse perspectives in evaluation. At the Grand Hotel, transformation took a different form. The corporate headquarters instituted comprehensive diversity and inclusion training for all staff. More significantly, they established the Future Leader Scholarship for underprivileged youth interested in hospitality management and business leadership. We're honored to have Ms. Caldwell serve as student advisor to our scholarship board, announced the hotel's new diversity officer during the program's launch. Her insight has been invaluable in creating opportunities that truly serve our community's needs. Nia's research continued to expand, now supported by a grant from the State University's Department of Criminal Justice. She presented her findings at the National Conference on Judicial Reform, where her methodology was adopted as a model for community oversight of local courts. What makes Caldwell's approach so effective, explained Professor James Richardson, is that it provides quantifiable metrics for behaviors previously dismissed as subjective perception. When you can demonstrate that a judge interrupts minority defendants 400% more frequently than white defendants, bias becomes difficult to deny. The state legislature passed the Judicial Accountability Act with rare bipartisan support. Governor Chandler signed it in a ceremony where Nia stood among the dignitaries. Key provisions included mandatory recording of all court proceedings, transparent sentencing guidelines, and an independent review process for complaints of judicial misconduct. This legislation ensures that what happened in Judge Langford's courtroom never happens again, the governor declared. Equal justice under law isn't just a phrase we carve on courthouse walls, it's a promise we must keep. Former defendants from Langford's court saw tangible results from the reforms. A special review panel examined over 300 cases, resulting in dozens of overturned convictions and reduced sentences. A class action lawsuit against the county resulted in a settlement fund for those whose lives were derailed by Langford's discriminatory practices. I lost years of my life for something a white kid got probation for, explained Marcus Turner, released after his sentence was reviewed. I can't get that time back, but at least now people believe what we've been saying for years. Law schools across the state updated their ethics curriculum to include the Langford case as a cautionary example. Bar exam questions now test understanding of judicial bias and attorney obligations to report misconduct. As Nia prepared for high school graduation, a letter arrived bearing the presidential seal, an invitation to join a special White House commission on criminal justice reform. Later, Nia stood at the podium in courtroom 3, now renamed the Equal Justice Chamber. Sunlight streamed through tall windows, illuminating the diverse crowd gathered for Judge Amara Patterson's inauguration ceremony. When I entered a courtroom last year, I couldn't have imagined standing here today. Nia began. I simply wanted to document what I saw to prove that the disparities in our justice system weren't just anecdotal, but measurable realities affecting real lives. Judge Patterson, a former public defender known for her commitment to fair treatment, smiled encouragingly from her position near the bench she would soon occupy. The wooden seat, once Langford's throne of prejudice, had been replaced with a new design. Slightly lower, facing the gallery directly rather than looming above it. Justice isn't a concept that belongs to judges or lawyers, Nia continued. It belongs to all of us. And when it fails any of us, it fails all of us. Dr. Simone Hargrove approached the podium after Nia's speech, announcing an expansion of the National Merit Scholarship Program. We've created a special track for students interested in legal and judicial reform, she explained. Our first cohort includes young people from diverse backgrounds, united by their passion for improving the system. The scholarship recipients stood for recognition. 20 students whose faces reflected the community's true diversity. Each wore a pin bearing the scales of justice, slightly tilted, but in the process of rebalancing. The courthouse itself bore little resemblance to the intimidating institution of before. Hallways displayed information about rights and resources in 8 languages. Community liaisons in bright blue vests helped visitors navigate the court process. A monitor in the lobby displayed the quarterly review of sentencing data, transparent for all to evaluate. The building hasn't changed, Nia Caldwell observed to his daughter as they toured the renovated spaces. But everything inside it has. Victor Langford had faded from public view, his disbarment finalized after he chose not to contest the ethics violations. The civil penalties from class action lawsuits claimed most of his assets. Former colleagues who enabled his behavior had undergone mandatory retraining or been replaced. Mark Phillips, the prosecutor from Nia's case, now worked with the Ethics Committee, helping identify problematic patterns in other jurisdictions. I was complicit through my silence, he admitted during a training session for new prosecutors. That's a burden I'll always carry. Nia Caldwell had found his own path forward, establishing a support network for parents whose children faced court proceedings. Navigating the system shouldn't require a law degree, he explained to a group of nervous parents gathered in a community center. Knowledge is power, especially in a courtroom. Nia herself stood at a crossroads of opportunity. Acceptance letters from prestigious universities covered her kitchen table, each offering full scholarships. She had decided to study law with a focus on judicial ethics and reform. Her original notebook, containing the observations that catalyzed systemic change, had been requested by the State Historical Society for their Civil Rights Archive. In her final act before leaving for university, Nia visited her high school, speaking to students in the same classroom where her research project began. I never set out to take down a judge or become an activist, she told the attentive teenagers. I simply documented what I saw consistently and meticulously. I stood firm when it would have been easier to back down. She held up a new notebook identical to her original one. This is still my most powerful tool, not because it contains anything special, but because it represents a commitment to truth, no matter how uncomfortable. The students leaned forward as she delivered her final thought, words that would soon appear on posters in courthouses throughout the state. Justice isn't automatic. It requires vigilance, courage, and the willingness to stand firm when faced with injustice. If you found Nia's story of courage and justice inspiring, don't forget to hit that like button and subscribe to PAP Stories for more powerful stories that spotlight systemic issues and the brave individuals who challenge them. Every subscription helps us continue sharing these important narratives that often go untold. Turn on notifications so you never miss our weekly uploads, featuring people who stood up against discrimination and created lasting change. Join our community of justice advocates by commenting your thoughts below and sharing this video with anyone who needs to hear this message of accountability.